All right, Mr. Herbert, just for the record, what motions do you have left?
Just a motion for new trial.
All right, I know you may have thought that you covered it before. You still have a motion to arrest judgment?
Yes.
All right.
I think we made those arguments. First motion.
All right. But could you formally present it in this portion, your motion for arrest judgment? Or it's very well written if you want to stand on that, which says a lack of jurisdiction, basically. And what this was about the compulsory joinder, it was very, like I said, it was very well briefed on your part. It's about the compulsory joinder and the 16 additional counts of aggravated battery with a firearm. Do you want to stand on that?
We'll stand on it, Judge, because I think it's probably more appropriate at that.
Okay, Mr. McMahon?
I'll stand on it.
Thank you. All right, the motion for an arrest judgment is denied. All right, at this time, Mr. Herbert, this is your motion for a new trial, your first supplemental motion for a new trial, and your second supplemental motion for a new trial.
Yes.
See that, please.
Thank you. Judge, as you know, we just like the first argument, we made a number of arguments in a written brief. We certainly stand on those. And I just wanted to address a couple of the arguments in more detail in my argument here today. The first argument that I want to touch on in the motion for a new trial concerns the jury instructions. Judge, there's no dispute in this case, there never was a dispute that Jason Van Dyke was acting as a police officer, that his actions whether they...
I'm sorry, Mr. Herbert, if there's no dispute, then you don't have to comment to that because that's in the record, right? Go to the specific legal arguments concerning the non-IPI instructions.
Sure. As the court knows, when a police officer acting as a police officer fires his weapon and shoots and kills somebody or shoots and injures somebody, it's very rare that they wind up in criminal court, state criminal court, for a charge, let alone a first-degree murder charge. And that's a relevant point here because, Judge, as we know, when a police officer does use force, they normally wind up in a civil case or a Section 1983 case or a Section 242 excessive force case with respect to a federal criminal charge. And the significance of that here, Judge, is the IPI instructions in Illinois for first-degree murder, they simply do not cover the situation concerning Jason Van Dyke acting as a police officer. When a police officer is charged with a civil suit or a federal criminal suit, there are instructions that are normally given which speak to the federal courts, U.S. Supreme Court's analysis of a police officer's decision to use force. As the court knows, we ask the court to utilize those same instructions so that the jury can look at these instructions and they can properly decide what their role is. What their role is to determine the reasonableness of Jason Van Dyke's actions when he fired as a reasonable police officer, not as a regular citizen. And unfortunately, that's what I believe the jury was forced to do in this case, with all due respect to the court. The primary instruction that we sought to have entered came from the United States Supreme Court in Graham versus Connor, where it talks about the reasonableness analysis required for police officers' use of deadly force. Police officers' actions have to be judged not only as the actions of a police officer, but one that's on the scene at that moment, rather than with the benefit and luxury of 20/20 hindsight. Of course, there was other ones from Tennessee versus Garner that we certainly wanted. The jury was forced to analyze this case and Jason Van Dyke's actions with a jury instruction that described the actions of a reasonable person. And I think the important point is that the jury recognized in this case that police officers are allowed to use deadly force in situations that regular citizens simply are not allowed to use deadly force. And that's where we kind of dovetail back to that inconsistent verdict, Judge. The inconsistent verdict, I think, is, certainly it's an inconsistent verdict. I don't know how anyone can argue that it's not. It's first-degree murder, not guilty, murder, guilty. Clearly it's inconsistent. But as the court knows, the only instruction, it's different when a judge tells the jury, here's your rule for analyzing this case. As a defense lawyer, I can argue that until the sun goes down, that, hey, you have to look at this as a regular police officer. But there's certainly a difference when the court is instructing the jury that you need to look at these actions of Jason Van Dyke as a police officer. So that didn't happen in this case, Judge. And with respect to the not guilty and the official misconduct, again, that instruction properly analyzed Jason Van Dyke's actions as a police officer. That instruction was the only instruction that analyzed Jason Van Dyke's actions as a police officer. The elements for the murder and the ag bat, for the most part, the state had little difficulty proving the elements in those cases, with the exception, I would argue, of justification. That is the element that we are arguing was not proven. And as the court well knows, the state has the burden to prove every one of these elements. And if the jury analyzed Jason Van Dyke's act of committing first-degree murder as a police officer and found him not guilty, I think that it is reasonable to infer that the jurors were confused and analyzed the other counts that didn't contain the language, forcing them to analyze it through the eyes and the prism of a police officer. I think it's reasonable to conclude that they're not guilty in official misconduct shows that they believed Jason Van Dyke's committed actions that were allowable per the law as a police officer, which of course would result in not only the validation for the not guilty in the official misconduct, but it would certainly also account for not guilty in the other charges as well. Aside from moving on from the jury instructions, Judge, another portion of our argument that I wanted to address was the jury question that was sent out on the second day of deliberations concerning a question that asked the court to inform the jurors whether they should view the shots, how they should determine the shots. Should it be based upon how the medical examiner numbered the shots, or should it be view the shots as a whole, all together? We, of course, objected to the latter language going back as a whole. The court, over our objection, that is the language that went back to...
Well, just be a little bit more precise. The jury formed the questions, right? And I selected you should use B. Didn't direct them to have a verdict or anything, but it was their language. Go ahead.
We believe that that the instruction that was provided to them...
Well, state the instruction so everybody in the courtroom and the record knows what it was.
It was, how should we analyze the shots? Should it be...
I didn't say that. I said...
Well, your answer, I'm sorry.
Yeah, that's all you're concerned with. The jury's question can't be reversible error.
Right. Your
So
answer was...
My answer, yes.
I believe it was considered...
Now, don't believe, come on, We're on the record. What is it? What was it?
Option B.
There you go.
Okay. So that's a significant point for a couple of reasons, Judge. As discussed by the jurors in various media outlets after the verdict, it was clear that...
I'm sorry, you know that you can't impeach the verdict. The other thing is, we had our outstanding media co-chairs question the jury right afterwards, and the prosecution was here, but the defense absent themselves. So you would have heard what every juror said. All right, so go ahead.
Sure.
But again, that doesn't have any legal significance whatsoever.
Judge, it was clear that the jury determined first and foremost the murder charges. They determined whether or not first-degree murder was proven, and then whether or not second-degree murder was a more appropriate charge. We know that that's what happened. The question, and the verdict came back shortly after this question. I don't remember exactly, but I believe it was within a couple of hours. After the question was answered, as I said, the verdict came back. Important here, Judge, is that when the question was asked, because the jurors, there was a significant amount of discussion and belief on parts of the jurors that the first couple of shots could be justified. And that's why, and we know this, that's why the jury wanted to know, well, how do we number these shots? How do we, if we want to say the first two shots are justified, how do we use the numbering system to say which one of those shots are justified? After the option was provided to them that they were to focus on B and look at them together, they came back with a guilty verdict, and they came back with a verdict of guilty.
Don't snap your hands, because the 2 hours don't go by like that, even if you're Einstein and relativity is appropriate. But go ahead. And they came back with a guilty verdict for 16 counts of aggravated battery. The significance here, Judge, is that if the first two shots were justified, then Jason Van Dyke cannot be guilty of murder. The state charged this case that every single shot was not justified, and they were required to prove that every shot was not justified and contributed to that murder. Well, I think there's significant doubt here about the first couple of shots. And if the first couple of shots were justified, it has to be a not guilty for the murder. Finally, Judge, moving on to our the venue issue. As the court knows, we argue that extensively. I want to focus on just one portion of the venue argument, and that concerns the timing of when the court denied our change of venue motion and the impact that the timing had on our decision. As the court knows, we filed briefs, motions, we had argument, and the court took this under advisement. The court did not give us a ruling. The court did not give us a ruling until after we were forced to choose whether or not we were going to waive our right to a jury trial. We had to decide whether or not we were going to take a bench trial or a jury trial. The state argued that we somehow waived that argument, or not demanding that the court issue a ruling before we made that decision. Well, we did. I mean, we can't tell the court, no, you have until tomorrow to make a ruling. We filed the motions well in advance. But when Jason Van Dyke made the decision to exercise his right to a jury trial, that decision was made with an expectation, however strong that may be, an expectation that the court would grant our change of venue motion. And it was reasonable for us to believe that the court would grant our change of venue motion based upon the extensive amount of evidence that we provided in support of
that change of venue. And we would submit it was overwhelming. So, so for that reason, I would say it prejudiced the defendant and requires the granting of a new trial. Thank you.
Thank you, Mr. McMahon.
Kind of three issues. There are three issues in the defendant's motion for a new trial. The first is he alleges that you erred in both denying his motion to change venue, and it was somehow prejudicial that there was a deferred ruling on the motion to change venue, either of which are supported in the record or warrant indicate any type of mistake or error by this court. In fact, the process that you followed, Judge, inured to the defendant's benefit. You took expert testimony, you received expert testimony from both an expert called by the defense and an expert called by me. Listen to that evidence. You could have accepted some of it, you could have accepted all of it, but you listened to all of it. You then tested that evidence. You repeatedly talked about using the scientific method, and that you were going to test both of those expert witnesses' opinions. One, an expert brought in from California who was somewhat confused about what the state of the law is in the state of Illinois. Another expert with credentials who extensive industry experience in the business field about gauging public opinion and gauging public awareness. You listened to that. You then tested it against every individual juror that came in. And I think what is important here is that you brought in, I think, approximately 200 people. We didn't even get close to exhausting 200 people, and it was.
I'm sorry, just a clarification. I brought in 200 people for their examination as potential jurors.
Yes.
Go ahead. Thank you.
We didn't even get close to exhausting that pool of people who you brought in for potential voir dire examination. And it was, I'll speak for myself, much quicker and much simpler to find jurors who either knew nothing about the case or knew something about the case, but could absolutely and swore under oath to you, defendant, the people of this state, they could listen to the evidence and render a fair verdict based on what they heard in this courtroom. They did that. That issue is crystal clear. There is no basis whatsoever to grant a new trial based on either the denial of the motion to change venue or the deferred ruling. By deferring the ruling, you allow this defendant to sit there and look at his potential jurors and then make a decision. You held off repeatedly swearing in the jury. You held off in paneling the 12th jury. All of those were measures put in place by you to protect the defendant's right, protect his decision and his ability to make a decision whether he wanted a bench trial or a jury trial. That is not a basis. There is just no evidence to support that claim of the defendant to grant a new trial based on the venue issue, either the timing or the ultimate decision. Second issue in his motion for a new trial is the court's decision to reject the non-pattern Illinois pattern jury instructions for criminal cases. What I want to point out here is that this is one of the areas in criminal law where it is the defendant's burden to establish that the Illinois pattern jury instructions somehow failed to accurately state the law, and that it's his burden to craft a proposed non-pattern jury instruction that is both accurate, simple, brief, impartial, and non-argumentative. He failed on all of those fronts. What the defense has tried to do is to inject a civil standard from the federal court system. And what I want to point out, we have fully developed this in our brief, which obviously we would incorporate here, Judge. But the Seventh Circuit pattern instructions in civil cases do not even have the defendant's proposed non-IPI. So that might have been a strategic starting point. Their strategy was something else. They don't have to disclose that. I'm not asking them to, obviously. But the non-pattern IPI instructions that they proposed, and they asked you to submit to this jury, failed on all of those criteria. They were not simple. They were not brief. They clearly were not impartial. And they were absolutely argumentative. They were not non-argumentative. The issue on the jury instruction, Judge, my recollection of that is, and I'm going to address it because he just brought it up in his argument here, but my recollection of that issue is that that was an issue that was raised in the defendant's motion for judgment notwithstanding the verdict. But under the People versus Childs case, which again we cite and we laid that out in our brief, that question required a response. And the response to their specific question that you gave, and was the right response, was the only response that was consistent with both the testimony and the indictment. And under the Childs case and the various cases that we cited in that portion of our argument, that was a required response, it was the correct response, and it was consistent with both facts in this case. It was consistent with the testimony from Dr. Arunkumar and even Dr. Tees, their expert, who they called about the ordering of the gunshots that were numbered on Laquan's body on the various displays. Dr. Arunkumar and Dr. Tees both testified that that numbering system is a numbering system used by the medical examiner as he or she does a physical examination of the body, top to bottom, front to back, as it was not the order in which gunshots were fired or inflicted.
Mr. McMahon, just refresh my recollection. Did either pathologist testify as to which bullet was first, second through 60?
No, they did not. Further, Judge, they both testified that they cannot testify as to what bullet struck an individual first. It's just the human eye cannot pick that up. Physical damage to a body will not reveal the order in which the gunshots were reflected. So that was a point that was agreed to by all of the witnesses who testified. Further, by the other medical examiners who did not testify, and Dr. Tees and Dr. Arunkumar relied on their reports and their examination. So I think that issue is very clear in the record. And the answer that you gave to that jury instruction was accurate, and it was the one that was required by law. Judge, very briefly, the last issue that I think is raised in the defendant's motion for a new trial is that the defendant argued that somehow in our argument or in the way that we presented our case, we misconstrued or we misrepresented the evidence about the presence of a taser or the arrival of a taser. Numerous witnesses, and this really was not, certainly the record speaks to this, Judge, but my recollection of the record is that there was really no dispute that a taser was called or that it was on its way. The defendant testified that he had a radio on his collar, and he had the opportunity to hear all of the radio traffic that set out that a taser had been requested, that a unit responded to the call for a taser, and that a taser unit was en route to the scene. Officer Ivankovich's testimony, and specifically People's Exhibit number 225, which was a video clip, established that Officer Ivankovich and Torres, police officer Torres, arrived at the scene moments after the shooting. Now, these videos had timers, and my recollection is that my co-counsel, Ms. Gleason, played that portion of the time video for the jury. So they had the opportunity to observe both the arrival of the taser unit, compare that in relation to when the first shot was fired, and they made their own decision about what that evidence meant, when it was called, who was aware of that, whether this defendant should have known that there was a taser moments away. We never suggested that Officer Ivankovich was the officer who verbally responded to that police dispatch requesting a taser. There was, to suggest that we somehow misconstrued that, or the jury misconstrued that, or that we misrepresented that evidence is just not borne out by the evidence. It's not borne out by the video of Officer Ivankovich arriving on the scene. It's not borne out by the radio dispatch traffic that was played during the trial and then presented to the jury, both by way of an opportunity to listen to the actual radio traffic, the transcript that came in to the jury without any objection. So to suggest now that that somehow was misrepresented or misleading is not supported by the facts in this case, and I'd ask that you deny the motion.
Thank you very much. Mr. Herbert.
I will address the last portion of the state's argument first, and that is with respect to the taser. And yes, Judge, respectfully, we did allege that the state misled the jury with respect to that taser. Listening to the state's argument, they stated that, well, we never contended or implied that Officer Ivankovich, the car that showed up shortly after the shooting was over, we never implied that Officer Ivankovich is the one that came on and said, I have a taser and I'm coming and I'll be there shortly. Well, that's because he didn't do it, which they acknowledged, but the person that did somewhat acknowledge having a taser said, I'm coming from a long ways away. Well, if Officer Ivankovich was not the individual to indicate that he had a taser, and if Officer Ivankovich, his arrival on the scene with the taser was unknown by Jason Van Dyke or any other police officer on the scene, how in the world could that be relevant to the analysis of Jason Van Dyke's decision to shoot? It wouldn't be. Yet it was argued extensively and shown. They showed the video of the car arriving, and they showed it in their opening, or maybe not the opening, but certainly in the closing of this vehicle showing up right after the shooting happened. Clearly, the jurors had the impression that Van Dyke could have waited a few more seconds, when in fact, what Jason Van Dyke believed is that to wait for a taser, he'd have to wait minutes, because his knowledge and everyone else's knowledge on the scene at that point was that this person was coming from a long ways away. But with respect to the change of venue issue, the state talked about how it was an experiment, essentially. You had to test the conclusion, and you tested the conclusion, and it was clear that there was the ability to have a fair and impartial jury. We disputed that at the time. We dispute that now. Yes, we picked the jury in this case. We were forced in this case to choose jurors that we never would have ever chosen in a different case. We had extensive information on all of the potential jurors in this case, and we knew the timing of when those jurors were going to become eligible for selection. We selected individuals that admitted to viewing the video and seeing the news reports, and we selected jurors after our motions for to deny these jurors based on prejudice. We had jurors that we selected that characterized the shooting as horrible, characterized the shooting as shot too many times. When we can't strike them for cause, we have to save our preemptories because jurors saying horrible and shot too many times, that is nothing compared to some of the jurors that were about to take their position back there. So I would say respectfully, Judge, I don't think that that the issue was proven, that there was not inherent bias. We maintain that we were forced to take a jury that that certainly was not fair and impartial, and we were forced to do that for all the reasons that we've argued here. With respect to the jury instructions issue, Judge, let's talk about non-IPIs, and as I argued earlier, we needed to have a non-IPI in this case because of the unique facts there. As the court knows, and as we've argued, Illinois Supreme Court Rule 451 mandates that IPI instructions be used unless the instruction does not accurately cover the situation at hand. And that was our position in this case. Judge, our defense, our statutory exemption or our affirmative defense was the peace officer use of force statute. The prosecutors were required to disprove beyond a reasonable doubt our defense of—
Mr. Herbert, you're being a little bit redundant.
Okay.
I heard this before. Go ahead. This is an important issue.
I'll tie it up to exactly what I'm talking about. The state was responsible to disprove our affirmative defense based upon the peace officer use of force statute. The fact that the jurors did not analyze our client's actions as a peace officer based upon the instruction, it is of no shock that they found him guilty when the standard was that for a reasonable police officer. It simply prevented the jurors from properly analyzing Jason Van Dyke's actions with respect to our affirmative defense, the peace officer use of force statute. And then finally, Judge, talking about that juror's note, if we think about the juror asking that question, and
I'm sorry, everybody, just take the question, all right, so everybody knows what it is.
How should we determine the—
Are you reading the questions? Come on.
Read. I'll, as soon as Randy
Sure.
diligently
Take
finds
your
it.
time.
Judge, but I will continue to argue until we have the exact language. But if you think about it, and I've thought about it, what other explanation would explain why the jurors would be asking that question? There is no other explanation, Judge, I would submit, other than the jurors clearly were in dispute or perhaps in agreement that one or more of the shots were justified. Otherwise, that question is irrelevant. And its significance here, Judge, is if that question—
Really, get the question so they know what you're talking about, whether it's material, whether it's relevant or not.
So if that question—
I'm sorry. Talk to diligent, Mr. Kim. Diligent Mr. McMahon got you the question.
For the record, motion's upside down as Randy was reading. Okay. the jury note said, are we to consider as, comma, A, comma, how the shots are numbered on the medical examiner's chart, or B, comma, the simple number of shots fired, and it's by the foreperson of the jury who asked that.
Thank you. Proceed, Mr.
So it just, that's what the language was, and my point is that if the jury's asking that question, they clearly have a dispute or a unanimous decision that one or more of the shots were fired. And the significance of that is, if in fact that's true, which I don't think can be disputed at this point, based upon that, then the charge for murder has to be a not guilty, because it has to be all 16 shots. And finally, the point about the pathologist, and this was an important point of our testimony, we were able to show through our evidence that we agreed with the state and the court in that colloquy about no pathologist could say they can get up here and say, shot number 1 happened here, and go all the way through shot number 16.
No, they can, on the body, they can say which shot was where, but they can't tell you which one came in first.
Agreed, the sequence. They could not do all 16. However, Judge, what the evidence showed was that they could definitively show which shots struck the front of Mr. McDonald, and they could clearly.
We're going into the, the geographic location on the body and not the sequence. The sequence is what you're arguing, right?
But I'm getting to that, Judge. Just give me 1 minute and I'll explain it.
I remember shots 2 and 4.
Right. And along the same lines, the pathologists both definitively could opine that certain shots could not have happened on the ground. Stated a different way, that they had to have happened when Mr. McDonald was standing. So based upon that, we were able to establish a sequence of the shots, albeit not an exact sequence. But our pathologist testified that shots number 2 and shots number 4 were the killing shots. And I believe it was shot number 4, which our pathologist, and I don't think it was disputed much by the state's pathologist, that is the wound that caused the most injury. The point I'm making here, Judge, is that injury was testified, not impeached. It had to have happened when Mr. McDonald was facing Jason Van Dyke, and it had to have happened, could not have happened when he was on the ground. So the significance of that is, if the jury found that a couple of shots were reasonable, they couldn't have found that the last 2 shots were reasonable. If they found that 2 were reasonable, they had to have found that the first couple of shots were reasonable. And our evidence is that the deadly shots, the shots that caused the murder, were in fact those first couple of shots. So with that, thank you.
Thank you. I want to compliment both the special prosecutor and his team and the defense, Mr. Herbert and his team. These legal memorandums and motions took a lot of insight and a lot of work, so thank you. As to the closing argument concerning the taser testimony, I find that the jury was not misled. The other factors involved in this, one, in my opening remarks to the jury, I told them that opening statements are not to be considered as evidence. And then I went further, and closing, after I explained the different components of the trial, I said closing arguments are discussion of the facts or reasonable inferences to be drawn from them facts along with circumstantial evidence. And again, ladies and gentlemen, anything that the attorneys say in closing arguments is not to be considered as evidence. And I said, I'll go one step further as a quality control. Anything that the attorneys say in closing arguments that conflicts with your individual recollection of the evidence should be disregarded. And I also gave a jury instruction towards that fact. So they were instructed 3 different times that closing arguments are not evidence. And twice of those 3 instructions, they were told to disregard evidence that conflicts with their individual recollection of the evidence. I find that that is my ruling on that. Now, as to the non-IPI instructions, the law is clear on that. My rulings were correct, so the motion for new trial is denied on that. Now, which is the motion, first motion for new trial, second motion for new trial, and motion for new trial. The third response and that applies to my reasoning on the closing arguments. Concerning the jury questionnaire, you have to look at the whole situation here. We put these people through very unpleasant circumstances, meaning the jury. They had to fill out, I think it was 27 pages of questions that dealt with some private matters. They had to go through the individual voir dire examination, which was constructed very outstanding by both the defense and the prosecution. And they had to sit here. And then when they give a question, the defense said, don't even answer it, which is perfectly correct as a legal tactic. But the other thing is just to be, I can say, I just don't see it any other way than being disrespectful for all the hard work that the jury had put in, just to ignore their inquiry. And then my finding was this was a hybrid type question, both containing fact and law, but I gave the answer to the instruction. As simple as that was, and not in a way to direct a verdict either way, to consider option B. So I find that there was no error in that. Concerning the motion for change of venue, the whole purpose of a motion of change of venue is to make sure that the accused is not deprived of a fair and impartial jury in the venue that the charges were brought. I'm going to go back and aside a little bit. There's much talk about testimony and about expert witnesses, etc. First of all, the jury resolves all those questions. What we have to understand, and it is the law, just because an expert says something, that doesn't make it so. It's not a fact. Otherwise, it wouldn't be a conclusion or an opinion. And the jury can give much weight or no weight to those conclusions. And they did so in resolving their deliberations. Now, concerning the change of venue, to say that now that you were forced to do something when actually you had options, there was two preemptory challenges not used by the defense. So at that time, and looking at the expertise and the quality of the defense, that was not something that they were going to say, we're going to accept a unfair jury and put our client on trial with an unfair jury when we have two preemptory challenges. As the record reflects, these jurors were fair. The purpose of the motion to change venue is to ensure that there is not a partial and unfair jury which would try the case. Therefore, there's also a constitutional principle, and you can write treatises and books about it, but basically it says, if there's no harm, there's no foul. Here, Mr. Van Dyke, the jury did resolve complicated questions, did find that there was a finding of first-degree murder, and then went on and saw and observed and determined, did the defense put evidence on that was mitigating and beyond a preponderance of the evidence? So they agreed that the defense did their job on that portion of the trial, and they accepted the evidence. These were not just radical type on the spur of the moment decisions by the jury, but very thorough, very complicated, and very correct. So the motion for change of venue is denied. So all the motions for new trial is denied. I'm going to take a short recess so we get scheduling on the sentencing, but I'd like to see the trial attorneys in my chambers. Who has the jury on the 17th of July? Yeah, call the case, please. Thank you. All right, I've looked at my schedule. I'm looking at January the 18th. What do you think is about you? All right, is that good for everybody?
Yes, it is.
Like that moment.
You said the 16th and 17th.
No, I said the 17th and 18th.
I got provers, so good. You keep that up. All right.
Friday the 18th.
You said the 16th.
Any other day in January except the 18th.
All right, well, I have to rearrange other jury trials and all that. So is that the whole week?
No, just that one day. Just that one.
Well, then we'll do it on the 17th.
That's fine.
I'm sorry, I can't.
All right, here, the tail ain't gonna wag the dog, all right? So you could come here or you could not come here. And if you don't come here, I guarantee you there's gonna be consequences. Order court, January 18, 2019 for sentencing. Thank you all.
Hey,